So, welcome everybody to Privacy Kitchen, and I'm super excited to have one of the data protection professionals I most respect in the UK, Claire Archibald here, founder of the Education Data Hub, and we'll get into that. Claire and her sidekick, Claire Wilson, gave a fantastic speech at Privacy Space in November. For those lucky enough to see it, I think it's one of the best speeches I've seen. And today we're talking about data subject rights in education. So Claire, so happy to have you here. And would you give everybody a sort of an intro to yourselves and to the Data Hub?
Oh, hi. Yes, I work for the Education Data Hub. We are a traded service operating out of Derbyshire County Council. Started up our service in 2019. Initially, it was a 1.5 person job, scoping out the schools within Derbyshire to try and find out what help they needed with implementing the GDPR. Started off with about 30 pilot schools. We were probably asking them as many questions as they were asking us. And fast forward 4 years, we are now about 350 school clients, including multi-academy trusts. And we don't just cover Derbyshire anymore, word of mouth, because we've got this traded service arm, we can trade anywhere in the country. So we've got clients as far south as Devon and Dartmoor, and as far north as Durham and Newcastle. I think, when we started our team, I think we thought we would go in, make a school data protection compliant, and then get back out, and that they wouldn't want us anymore after they'd got to compliance. Actually, that's not happened at all. We are really embedded into schools' cultures. We've got really great relationships with our school clients and the schools, and we've really made a big change in some of the schools that we work with, and that is so rewarding.
Yeah, I can imagine. And also, I mean, I can understand why the relationship holds and sticks, because schools are so tight on resources, and you guys are so great at what you do, and what you give is so practical as well, which is also what we're talking about today. But also, as you say, it started with GDPR, but you've expanded out across the whole governance and security aspects.
That's right, yes. So we started off just going in and looking at data protection and data protection compliance, very much looking around that legislative framework. And as we went into schools, we started to open cans of worms everywhere, to the point that I thought there were great big catering size cans of worms that I was opening all over the place as we dived into cybersecurity or how schools were managing data. And so we grew out of that then, and we already had a team supporting schools with their management information systems within Derbyshire, so that felt like a natural bedfellow. And then we expanded into cybersecurity, and we now have a cybersecurity team. But we're all one team. We just have kind of different focuses. But we all work together, compare notes all the time.
I love it. I mean, it's massive growth. You're talking only about sort of 3.5 years or so, and you talk so relaxedly about something that's a massive growth in scope and in service delivery and everything. And I think that's what is so exciting about this conversation, because you make it all very achievable, which I think is the big thing about trying to help people achieve these results. So let's look at data subject rights today. So in terms of most studies are commercial studies that come across, that people come across, and commercial studies basically say access rights and erasure rights, sort of 80% of people get them who get data subject rights. They're the most common. And there's a big drop off to about 25% get sort of correction and portability, that sort of thing. How does that relate to the education sector in terms of what sort of data subject requests do schools tend to get?
I would say probably 98% of them are access requests. In terms of the data subject requests, we also get lots of freedom of information requests and requests under the specific legislation for schools, which is the Educational Information Records requests. Slightly different to ours, lots and lots of crossover. But very, very small percentage would be data subjects exercising their other data subject rights. Those very small minority of cases, then when you are looking at those, they're immediately very complex. They're almost immediately tied up with complaint and really ongoing, broken down relationship, pages and pages, very long emails or letters from data subjects, down exactly what they want. So as soon as we're looking at other data subject rights that aren't access rights, we're immediately in the territory of this is going to be very, very labour intensive. It's going to take a lot picking through long and complicated communications, and then being really, really considering the law very carefully and picking through the legislation, the ICO guidance. And there's hardly kind of any case law to really help us when it comes to those other rights as well. So it can be really complex.
One thing I want to just bring forward in our conversation now is a little bit is, we'll talk about sensitivity a bit later on, but when you have an access right, are those not also quite charged? Because you've got everything's about children, parents. I mean, it's not like a consumer buying a fridge from a superstore or something. It's really an emotional topic. How many of the data subject requests then have this emotional baggage, and what sort of scale of stress is that emotional baggage on a typical DSR?
I would say nearly all of the access requests that we deal with are complex. I think somebody said once, you don't make a subject access request in order for you to reflect on the happy times your child has had at their school. So almost all of them have special educational needs agencies involvement, so lots of other third-party agencies involvement. They often have behavioural elements. There's very often child protection issues, safeguarding issues, police involvement, courts involvement, split families. So you've got mums and dads who don't have any contact with each other, who might not even have each other's mobile telephone number. Yet dad's putting in a SAR and he wants to know who's the emergency contact, and so everything gets, and you can't take anything for granted.
Well, that's something we'll definitely get into in a bit more detail in a moment. It's something that I think a lot of practitioners will be struggling with. And in terms of number of data subject requests, and obviously, as you mentioned, there's freedom of information, there's educational records as well. But in terms of, let's just say, data subject request, when someone says, I want the data about my child, how many does can you say, like, there's a typical number a school gets? Does it matter across regions, and does it matter primary, secondary? Does it matter size of school? What sort of can you give us a feel for how many requests a typical school gets?
For some school clients will be really, they would say they feel punished by the amount of SARs that they get. And some schools won't get any for years and years. And then I'll be doing my proactive work and talking about their compliance and saying, do you know how to deal with a SAR when one comes in? Like, oh, we've never had one. And I sort of start to probe, well, maybe you've had one and you've not realised. Are you dealing with them? And then the head teacher will explain to me how they culturally engage their stakeholders, and they invest very heavily in making sure they have a really open culture within their school. So the first sign of any upset, any problems, they will invite the family in. They're very transparent throughout, and that culture then pays them back because they don't get SARs in response.
Right.
Schools that have a more of a cultural issue in terms of maybe not engaging with their communities very well, you might say they get a lot more SARs. And SARs tend to be a bit infectious as well. So parents will talk to each other in the playground, or they'll talk to each other on social media, and they will encourage each other to put SARs in. So you could have a run of SARs in a particular school.
And so that's a very interesting point about the culture of the school. Obviously, there's lots of other benefits from having a really good culture from the school, with communication and openness and transparency and safeguarding, et cetera, and trust, I suppose, is at the foundation of it all. But that's interesting. I just want to pick up on what you said, that one of the benefits of a school, maybe an unforeseen benefit for the school, of having that culture with its stakeholders, is that they do then have a reduced number of data subject requests.
Absolutely, yeah. I think time invested is time well spent. So in our team, we structure our team around making sure that we don't, just as data protection officers, fall into filling our weeks up with reacting to problems.
So
we preserve a couple of members of our team to make sure that we're constantly on that proactive work as well, because putting the and again, it's for a school, it's really easy for them to think, oh, well, I don't need to do anything because I'm not having any problems. But actually, the more you invest in time, it will pay you back, because then you don't have those horrible complex issues that come out of it, because you've invested invested in your records management, for instance, so that if you do get a SAR, you can quickly and easily put your hands on everything.
I think we've got resources and processed on the agenda for a little bit later on. This is really presaging those really well, because I think it can be very difficult for a practitioner. Often we find, and I'd be interested in your view, that a data protection practitioner is often, it's not their 100% role, so it's added on to another role, and it can suffer from that point of view, from both the organization giving it the importance and the headroom to do that sort of proactive work, but also from the individual. They can be a bit snowed under on the other role and think, well, actually nothing's coming here. Do you find that as well in education?
A teacher said to me once, when we were dealing with a particular nasty issue, they said, oh my gosh, I didn't realise data protection doesn't matter until it matters, and then it really matters.
Yeah,
that's absolutely brilliant. Yeah, because when you've got a problem, it becomes all consuming. And when I mean all consuming, I mean a head teacher can spend their entire working day working on a data protection issue, and very often what I will see is the head teacher will be, doing their substantive role in the daytime, and then 4 o'clock, when children have gone home, then they will get round to the really nasty data protection issue that's been sitting waiting for them, and that can feel very emotional. They're very tired. It's the end of the day.
I've
had head teachers crying on the phone to me 5, 6 o'clock at night, because this is just so overwhelming, and I really don't like to see school staff really struggling with their mental health around data protection issues. It does happen, and so what we've got to do is we've got to make sure that we're putting that proactive work in, so that they feel confident and ready, armed.
And then, so this is an interesting one with the technology advancement. How are data subject requests received? So a lot of studies, again, commercial studies, sort of say that it's roughly split 50-50, that there's half of them come in by phone and email, and the other half come in through some sort of a portal or just a web form, or a form that's on the website. In education, how do schools tend to get the requests?
So we have not had one request via a portal as yet. They 100% have been via email or in a meeting, occasionally via a web contact form on a school website. What we do see, I think, is a lot of data subjects who will use templates provided by either something like a send support group on Facebook. I think they had a template, and there are obviously some privacy activists who produce templates. Sometimes those templates are helpful, sometimes they are not, because those templates actually encourage people to put in very, very broad SARs, which don't actually help the data subjects or help the schools to get the information to them really, really quickly. Because schools at the end of the day, the schools are there because they're passionate about children and the families they serve. They're not there to obstruct them or to stop them from getting the help that they need. They want to really help them. What you see when you get these templated SARs is, I want every last bit of information you ever wrote about me, including this, that, and the other. And actually, if you came in and had a conversation sensibly and said, look, I really want to put in, an application for some extra funding for my child, and I need some information to support that. Can you help me? The schools go, yeah, definitely, we're going to help you with that.
Yeah,
because we want that.
This is a really interesting. This is a really interesting one, because, and let's dive into this, because the number of private enterprises that feel that they can even ask a data subject or the person filing it do you want everything, or are you actually bothered about a particular period of time or a dispute or whatever it is? Because if you want everything, you're going to get all this stuff, and we don't think you want that stuff. And the ICO even has in its guidance, and the EDPB, and they're just updated guidance. So, you can overwhelm a data subject with a massive response, and actually they might not, you could layer it, and maybe they only actually want one particular part. And the new EDPB guidelines say you can respond with what you think they most want and give them a hint about all the other stuff and how they can get it. So in terms of education, you've got a very different relationship with your stakeholders and the people talking, and they tend to, I suppose, people who file them actually want to be heard. How do you find that schools are reacting to those in terms of how happy they are to reach out to the submitter to say, do you want all of this? And actually, are you focused on this? And how do the submitters respond to that discussion?
Yeah. This is hugely difficult because submitters are already in a place where they're unhappy.
Yeah.
They're not, as I say, they're already prepared to be unhappy. They're already prepared to complain. So when you go back and you say, oh, well, do you want, then you've got to tread really carefully because you don't want to inflame an already inflamed relationship.
Yeah.
And I think a lot of data subjects, when they put in a SAR, they think they're going to get that smoking gun, don't they? They think they're going to get a document that's, I knew the conspiracy.
Yeah.
And that there just isn't that.
No.
Those documents don't exist. People, generally professionals don't go around being unprofessional, saying unprofessional things about subjects.
Yeah.
They work really hard to help those data subjects, as I say. So you've got to be really careful in terms of going back and clarifying, because then that could further antagonise and inflame. And sometimes it's easier just to go, this is all of the information we have, and actually, you probably weren't interested in the, what you paid for your dinner money over the last 6 years, but heck, here it is anyway.
Yeah, well, maybe we can bring forward the resources, because this goes straight into resources where, schools are now. So I'm a bit, again, speaking as a parent with an opinion. So I mean, I'm probably
opinions.
Opinions, yes. So looking forward to your true experience, but in my sort of view, I would expect that schools predominantly scale up the teaching, the help, the safeguarding, the support, the whole holistic support of the child, and the actual, IT department, the sort of procurement department, is going to be less bulked up, given the resources. You go, look, we've got to really look after, given the sort of the priority of the child. And so in terms of resources, I suppose there's two things. One is, when you get a data subject request as a school, what's the typical school got until they come to you? What sort of resources does a typical school have when they get a data subject request? Who deals with it? What role deals with it? What support do they have? How many people? How much cash is available? Is there a budget? What sort of tools do they have?
Okay, so this is really how long is a piece of string kind of territory, because schools come in all shapes and sizes. So my smallest client at one point, I think, had 18 pupils and had a head teacher and a lady that worked in the office, who was also the clerk to governors, who was also a teaching assistant, who was also a designated safeguarding lead, and had that kind of 2 people in. So that's the smallest thing, and those 2 people are responsible for everything. They might buy in a bit of external IT support. Now that sort of school is much easier in terms of resourcing, because those 2 people know everything. They know all the pupils' data is. They know exactly how to get their hands on it. Again, they're not massive schools. They've got to wade through hundreds of records. And so that sort of school actually deals with a DSR better than a really big, well-resourced client. It's completely opposite of what and those small schools as well also tend to have a very risk-averse approach. So they can't according to their means. So they don't do really adventurous things with buying ed tech. They don't have the money. So, they have relatively few places in order to search for SAR, relatively uncomplex systems to penetrate to get
a limited IT estate to search, basically.
Yeah, absolutely. So you get your big clients then. So a big multi-academy trust might have 20 schools in the trust, so they'll have some central staff in the central school central trust office. The central trust office is never as big as you think it is. It's always 5 people doing a lot of stuff, and usually looking quite frantic. But you will have like an IT director in the centre of that trust, and that person will have like a kind of global kind of login for all of those schools. And very often they try, and so their trusts are about trying to take the burden of that sort of stuff away from the individual schools, so individual schools can focus on the teaching and learning,
Yeah.
and then take some of that administrative burden and compliance governance burden away from them. What happens then is you get somebody who's in an office that's kind of many miles away from the school. They are an IT bod. They get given the SAR, right? We've had a SAR for Johnny Jones, and they go to the console for the cloud-based platform, say it's Office 365, type in Johnny Jones, and then they get 40,000 documents.
Yeah.
Because he's on every class list, every register, all of this sort of stuff. And that is a massive problem. So actually you'd think the big clients, better resourced, more competent with technologies, actually makes dealing with SARS harder. It's completely the opposite of what you would think.
It is. And then this brings us to another one. So another bit on the resources before I ask the next question, which is on the resources, because obviously there's so many different flavors of schools, but where do councils and local authorities come in terms of support and resources? And this is then my next question that's related to all this is data sharing and who's the controller. And obviously a data protection officer can be external and they can act for more than one controller. But where you've got, say, the local authority, you've got an academy, or you've got a trust, you've got different schools. So first question is, how does the local authority, how does local government, whatever form that takes, help? How does central government help? And then that's going to be quite a long answer, I think, discussion. And then after that, how does the controllership sort of fall out when you've got these different entities? So let's have a look at the sort of governmental help, as it were.
So first of all, we've got really clear guidance, and it's been set out. Schools are data controllers in their own right. They're completely separate from the local authority. And I know I'm DPO as a service within a local authority, but my client is the school. I act for the school, and I don't act for the council. There are people in the council who are data protection specialists, information governance specialists for the council, but I sit separate to them. That can be quite fun, actually, because sometimes I can, there is instances where you'll have interaction between the school and the council. And so I will need to speak to a colleague in the council, but I'm representing the school, even though we've got the same employer. The school, and they represent the council, and we have to talk about a data breach or something like that. Who is responsible for this data breach? There's been some good, interesting conversations. Massive advantage for schools to have their DPO within the local authority. I would say that because that's what I do. Because there is, when you've got the council as a controller, and this, across the whole country, you're going to have your local authority being really involved in things like social care, exchanging of information around deprivation, community support grants, things like the holiday and activities fund. The councils and schools have to work together to make sure that data is shared to facilitate that sort of activity. So it's really advantageous and in SARs as well. So sometimes a data subject will put in a SAR to the school and to the council, and they will have documents in common. And as you know, sometimes when it comes to applying data protection exemptions and therefore looking at fact in a document, it's an art, not a science. And the person who's reading that and their understanding of things does come into play. And so it can be a really important partnership to make sure that you're consistent across the council and the school in terms of how you're applying those redactions and those exemptions.
And then
it's an advantage for schools, for the local authority. But in terms of what's available for schools in terms of resources, so there's lots of different options. So schools, data controllers in their own right. Some local authorities provide their own DPOs for schools, and that's just what the council do, and schools can have that if they want. Some it's traded model like ours, so schools can have it, but they can buy it. So they can buy services from anywhere, but they choose to buy it from the local authority. And we have a number of products, if you like, in the local authority that schools can choose or choose not to buy, whether they're maintained or academy or whatever.
The controllership's interesting. When a school receives a data subject request, how often does the person dealing with it have to consider, actually, this also touches on, say, safeguarding at a council level? Or, because as you say, a lot of the topics can be about that support.
Mm.
How does the person dealing with a data subject request go through that thought process of whether I need to not necessarily escalate it, but raise it with a different controller who's going to be involved in answering this?
And again, it's a real complex thing for individual school staff to do. If they are not doing this day in, day out, those questions can feel really overwhelming. For us, it's a well-travelled road in terms of looking at, whether it's reasonable to disclose without an external party's consent, or whether you need to go and get consent. Do you leave the email address of the social worker that's been corresponding with the school in the cell? Do you take it out?
Yeah.
Do you take the midday supervisor's name out? So she's, maybe the midday supervisor has logged a safeguarding concern and their name is at the bottom. Do you leave that out?
So while you've raised that, I'm going to pin you down.
Yeah.
So this is one of those things. So when you're going through the data subject request and you're looking at, because obviously we've mentioned already that they don't get the documents, and people are often after a smoking gun, and they don't realize they're not going to get the whole document. They're going to get their data out of the document. If there is, and then the other bit is about information on third party persons, non-data subjects, or rather not the data subject to the request. When you get that, there's a structural test to decide whether you include that data or not. How does a school typically deal with those cases you just mentioned about the person who's been looking at safeguarding, or the person who was doing the midday workshop, or what have you?
So my broad rule of thumb is that the head teacher's name would always stay in, and the individual teacher's name would always stay in. And then it depends on things like ancillary staff, support staff around that, whether it's appropriate for them to be individually named. It's a bit like, when you look at an FOI and you're talking about whether you're releasing somebody's name within an FOI, and you kind of go, the more senior they are, the more they've got to be prepared to put their name to the document, and the junior and stuff. So it's that kind of principle that is applied then to the DSR stuff.
And then that's where it's reasonable to include it without asking them for consent, and then you move forward. And
consent gets hugely complicated in schools, because you've got young people who are at various stages of competency in their lives. We don't have a clear-cut thing. And also, some of our clients are special schools. So you've got a whole added thing there in terms of their young people, and whether their 16-year-old pupil is competent or not, because it depends on their special needs.
So let's move to that now, because this is so age is a really interesting one. And so Scotland has this age of 12 that they say if someone's 12, they can make their own consent mind up and go forwards. Obviously, GDPR has an age of 16 that then member states can reduce down, and the UK reduced it to 13. Obviously, primary and secondary in state changes over at 11. So, primaries are probably, you just go, well, we need parental consent and yada, yada. If it's secondary, then you've got this split on the age, but then also you've got Scotland saying 12, you've got Information Society Services is 13. It's not really consent around anything else. And then you've got, as you say, you've got capacity, for want of a better word, of the data subject, the maturity of the child.
And then you've got educational records requests, which states the parent can make a request to view or a copy of their child's educational record, unless it's not in best interest of the child. So a parent of a 15 or a 16-year-old can still put in that request and consent from the child. And of course, that legislation only applies to this is so complicated, applies to maintained schools, doesn't apply to academies.
And it's different in Scotland. It applies differently in each of the nations of the UK. Yeah.
And then you've got children who are turning 12 mid-year, or children who stay in school and then come back for a sixth form. Where's the right time to ask children? And then I know we're going to be talking about biometrics, but then in terms of things like Protection of Freedoms Act says that parental consent must be sought for biometrics for children under the age of 18. Right. So how on earth do you piece all of these different things with consent and competency together? I think we did have one junior school actually where the school did deem an 11-year-old to be competent to exercise their own consent. I think my 11-year-old would have been very cross if she'd have felt that she couldn't give her own consent, because she felt very grown up at 11. So all of these really, really complex issues layering on top of each other. Schools under-resourced in terms of, we mentioned this in terms of, quite rightly, they prioritise teaching, learning, safeguarding with their budgets, and then you're going, well, actually, we've got these really big questions to ask. And when you're looking at school budgets, the last thing you want to do is take staff away from being to children. So where do the cuts come? They come in the back office. Yeah, exactly.
We've talked a little bit about the process, as in the management of a data subject request when it comes in, and so can you take us through how much is automated and how much is manual? So there's manual, automated. Obviously, the search is automated, like bung a name in Johnny Jones or whatever. How talk us through how schools deal with them?
I'm laughing because there's a particular scenario that's particularly ludicrous when it comes to automation, and I'll tell you what that is. So schools have records across a variety of different formats. I think one specialist in data protection was, Doug said, how ridiculous, you should just be able to pull it all together. I was like, you have no idea the disparate systems that are used by schools. So it's mainly manual. Some of the EdTech products have tried to do some things to help schools in terms of a SAR. They might have a button that says, press this for your DSR stuff to come out. And one of them says, press this for your DSRs to come out, and do you want redaction to be applied? So, school might go, yes, I want redaction to be applied. That'll save me some time, thank you very much, because I might have referred to the fight that Johnny's had with Billy in this record, and so I don't want Billy's name to be in it. But this technology also redacts the actual data subject's name out of all the documentation as well. So sometimes schools will give us this thing, and they'll thought they're being helpful by doing half the work and applying the redaction. Then we get the safeguarding record through. Makes no sense whatsoever, because it's got nobody's name, even the data subject. Automation doesn't work. And again, sometimes, so it's manual process. What we try to say as data protection officer is just send us everything. We will decide on the exemptions, because what we do when we apply exemptions is we will also be creating a kind of reasoning document. So for every, because we try to be as transparent as we can, mark it up with a number in terms of corresponding to redaction. Make a note, side note, while we've done that. And again, sometimes schools will think they're being really helpful and will send us stuff through where they've already gone through with a black marker. Well, no, can you send it again to us without the black marker? We'll do it because we need to apply the reasons and all of that sort of stuff.
So this is very
a manual.
And so we were talking before the session about a couple of different cases, and there's one which is Dear against Oxford, and Dr. Dear was an academic at Oxford, and there was an employment tribunal dispute, and then it went to court, and then to the Court of Appeal. Very helpful Court of Appeal decision. As if we don't have many decisions on it, but there's some more coming through. And one of the things that was startling on that, I'll just get the exact numbers, was so Oxford had already done a data subject request and fulfilled a lot, and then Dr. Dear felt it wasn't complete, so then went to court. And Oxford was ordered to carry out searches of servers for data containing emails or electronic documents sent or received from 22 named individuals between specific dates, and servers used by 5 departments and faculties for that. So quite a scoped one. It cost £116,000. They got 508,116 emails and documents. They used a law firm to search for the name, agreed to be on a case-insensitive basis and go against the name, which whittled that down to 8,000 documents, 3,500 irrelevant, 3,500 legally privileged, 733 referencing the Dr. Dear but not representing her personal data. And at the end of the day, 33 documents that hadn't previously been done, 0.4% of the 508,000 at a cost of 116K. How do schools afford, any business really, but how do schools afford that process you've just discussed?
So, what the situation in Dear versus Oxford feels very, very familiar.
Right.
Very familiar in terms of, those initial searches bringing up that information. So this is where that proactive work that we do with schools is so important. And, I am becoming more and more passionate about records management, the more experience I'm having in this. Records management is absolutely critical to a school being able to manage SARS. It's your best friend in data protection, good records management.
Yeah.
So, and then what you do is you say, well, we manage our records this way, and we go back and we say, all emails that are pertinent to any HR or issues or whatever are saved in your HR file. The rest we dispose of after 6 months. Yeah. And then you can go back to that data subject and say, we are only required under the law to undertake a reasonable search. What is reasonable in our organisation is that we search the HR system, blah, 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 or whatever. And then we say it's not reasonable for us to do any more because we have a good records management programme and we manage our records according to that programme.
Yeah. There's also the one.
That's your defence, and you push it back on that. But you can't. If you're not managing records properly, then you don't have that available to you as a defence, and then you get into that situation as they did in Dear, as we've seen in a couple of our clients, where you're having to consider and whittle down thousands and thousands of documents.
It's and records management. You're absolutely right. And one of the things there I always say about retention and you talked about email retention. A lot of people use email as a sort of storage mechanism, and they search an email, and to get them out of that cultural feeling to go, look, if it's important, PDF it into this folder or something like this, and everything else goes after a period of time. Because the less data you have, the less envelope you've got for breach, but also the less envelope you've got to search.
Cyber risk as well. The less data you've got, the less your cyber risk is. And there was a newspaper article about a cyber breach in relation to a number of schools a couple of months ago. And one of the things that really stuck out for me in relation to that was that the newspaper article said there was one folder marked passports, where passports of parents and pupils were stored in a folder going back to 2011.
Wow.
What on earth was the school doing, holding on to passports, from 2011? Yeah, there is a very real scenario where schools do need a scan of a passport because they're organising potential a trip or whatever. Those should be destroyed the second the trip is finished. There's no way they should have been a folder called passport scans back to 2011. Records management, best friend when it comes to SARS, reducing the cyber risk, reducing your carbon footprint in terms of the amount of data that you're then having to reduce the electricity that's consuming. It just goes on and on.
And there's an interesting
records management. I heart records management badge.
Yeah, and I should mention that you've got a couple of speeches or talks with the Records Management Society that are up online as well. So we'll maybe put links to those after in the notes, because on identification. So identifying, you mentioned earlier, there's maybe parents have split or whatever it is, and there's all this issue about the sensitivity. People did say, well, I want your passport and proof of address at the beginning. And then that's now understood. A lot of people at the beginning were, that's not really proportionate, but it was a knee-jerk response. And it was very, very common for people to ask for passport scans and a utilities bill or something. And then that's really been kicked out by regulators, et cetera. And it's come through that that's not proportionate. How do schools decide what's proportionate in verifying the identity of the submitter? So
by far and large, the SAR comes from somebody that you are having a mix of communications with. So you're seeing them face to face, you speak to them on the telephone, then they send an email. It's an email address that you've already got registered on your management information system. You're really confident straight away that there's not an ID issue. Occasionally, we will get a SAR from a parent where the child's no longer at school. you're not in regular contact, maybe it's a parent who has parental responsibility but doesn't have day-to-day involvement in their child's
Yeah.
care. That's a really difficult one, because then you've got to be you need to go back to maybe the child or the parent that does have responsibility for the day-to-day care and say, we need to talk about the fact that we've had a SAR in from somebody who says, you're your dad. And again, there's a risk there in terms of almost like a data breach in between.
Yeah.
The
Yes.
parents. It's just never ending in terms of the complexities that you have to think about. Because if you go to mum and say, we've had a SAR, can we verify, is this person that person's parents? They could then, the father could then come back to school and say, you've breached my data, you've told this person, my ex-partner, that I've put a SAR in or whatever.
Yeah. And how, in terms of fulfillment, how many, obviously sort of, this is qualitative and stuff, but how many do you think are fulfilled by sending a zip file to an email, putting it onto a secure server, sending a link and saying only you can go and get it from this link or what have you, or some sort of web portal? And how many are, well, why don't you come down to the office and here's a hard copy? Like, how many are electronic, how many are hard copy, you think?
So generally, I mean, we do different ways of the data. In the education data, there's two different ways we can do it. We can either kind of act as the school sort of messenger, so that they can contact the data subject and then they come to us and then we pass it down. So we give the data back to the school and then the school releases it to the data subject. And again, if there's a regular contact sort of point, then they usually just download it, print it, and give the physical hard copy. Occasionally, though, where relationships are really broken down with the school, we will talk directly to that data subject, and in those instances, the majority of them are done via a secure portal.
Yeah,
it's put on the portal. They have access for 10 days. You have a password to go with it, and then the requester doesn't then access it within the 10 days. And then comes back to us and says, I can't get in. We're like, the 10 days has expired. So then we have to re-upload it and re-release. There's a new password. So every little step in the whole DSR process is fraught with difficulty in education.
We talked about motive, and this is something that again, the joined case with DEA was very good on this, about motive for, actually, it was Dawson Dame as well. Motive for a DSR doesn't matter. So, and there's a bit of a fine. So generally, and this came through in EDPB guidelines, the new ones, the V2 bit, you shouldn't ask why they're filing the DSR. You just say, well, what is it you want? And you give it to them. And then obviously you've got this manifestly unfounded and excessive, or vexatious potentially coming and excessive. And it's the manifestly unfounded sort of vexatious bit. When do you look at where motive, we shouldn't look at it, and then where does that feed into something being manifestly unfounded?
Yeah, I think for me as DPO, I find manifestly unfounded quite difficult. I think the bar is set too high for something to be manifestly unfounded. So every time I'm thinking about, is this straying into the territory of manifestly unfounded, go back to the ICO guidance and read it again and go, oh God, it's not quite that bad. It is vexatious. And that's where I think the change in law will be really interesting, because once you start introducing the word vexatious, then all the case law around what's vexatious becomes open to us as professionals to say, well, that's actually vexatious. I think vexatious is the lower standard than manifestly.
I think that's clearly what they're hoping. Exemptions, we mentioned exemptions earlier, and all these different like educational record and what have you. How do you look at exemptions in the environment of the educational system on a DSAR? How do you manage exemptions? What are the most typically used exemptions that a practitioner might need to be aware of?
So in schools, the exemption to really focus around is in terms of risk of harm to a data subject, and usually the data subject themselves. So my little example I always say to schools is, I say, don't worry, because obviously schools then start to think, oh my gosh, I mustn't write anything down because it could be requested in a SAR. And that's really harmful. And when you look at some of the serious case reviews into child abuse, and you're looking at the concerns around care of children, lack of information recording and lack of information sharing is very often a common theme. So
Right.
that's why John Edwards has done a video to practitioners in education and social care and said, don't ever be worried about sharing information about a child. Don't ever let data protection come in between you sharing information about a child who's at risk, recorded information that a child's
Right.
at. So that for me is a crucial exemption. And the example I always give, as I say, is, you know, if a parent, if parent makes a SAR, and in the paperwork, you've got a record that little Johnny said mum hit him before he came to school that morning, then you're really looking at always redacting that, because you're going to put little Johnny at risk if his mum then gets information that he's come into school and said he's been hit by his parent. So, and that's a really crude example, but there are lots and lots of nuances around risk to data subjects in terms of, particularly risk to very little data subjects. So, you know, my 4-year-old data subject, who I think of, you know, I go to the local supermarket.
My 4-year-old data subject.
Children going around with me. And when I'm in the local supermarket, I can see their children and they've got their little school jumpers on with their little logo. I think, I look after your data. I look after you and you don't know. But, you know, you think about those little subjects, they're particularly vulnerable. They put a lot of trust in the adults in school and they tell them things that they wouldn't necessarily tell their parents. And so you've got to be really, and they're not competent enough to exercise their own rights. Their parents are going to exercise it. The parents really want to know what little Johnny's been saying about them when they're at school. Key exemption. So, you know, exemptions around social work and education too as well. So
I think that's also given us a window on, one, your passion for this, and two, just how tough it is in education with the sort of things that just you don't get in a commercial setting. So thank you so much. I think we've gone slightly over time, but this has just been such a fantastic conversation. I knew it would be. And so obviously the hub will put the details up and link to the hub and everything, and your talks to the records management. And thank you so much, Claire. That's been just before we wrap up. If you had like the top X number of tips for a practitioner or the school in terms of data subject rights, what would they be?
Number one, really do that proactive work with your stakeholders, make sure they're engaged, make sure that you're being transparent with them. I think, you know, don't ever do something like walk into a meeting and say, here's a folder of information I've got about you and you can't have it, because that's guaranteed to immediately receive a SAR. Number two, records management, of course, you know, making sure that you are getting that information in a really easy to access, easy to find format, and that you're only keeping what you genuinely need to keep. If it's not a record, keep it. And number three, then, I suppose, in relation to the actual administration of the SAR itself, in schools, I would say don't let the rush to comply with the statutory deadline mean that you rush through and are careless and make mistakes, because it could lead to the risk of harm to a child, and that is not what you want. So, you know, and be really transparent with your data subject, the requester, about this. So if they want some information and it's going to take you a long time because it's complex, because there's lots and lots of material or whatever, first of all, make sure that you find it complex and tell the data subject that you found it to be complex, and be really transparent about that. And then, you know, invite the data subject. We can respond to your SAR quicker if we narrow it down. I'm really interested in the more we can narrow it down, the quicker we will get it over to you. And then in terms of the complexity, you know, you don't have to release everything all at once at the end when you've done the job. You can release, right, well, we've dealt with batch one of the information, that's here, you can have that now. And there's more material to follow, so that the data subject is reassured that you are dealing with it expediently. And I always tell data subjects, you know, if you're unhappy with how I'm dealing with it, So the schools, if you're doing the communication, if you're unhappy with it, our data protection officer details are here. You can contact them, you can phone them, you can talk about it, because we're people trying to help you as people.
Yeah.
I always tell them as well, of course, you're free to complain to the ICO, and here's the contact details for the ICO.
Yeah.
And to be honest, I usually do put there in the bracket with the ICO, you can complain to the ICO. I say, but please be aware the ICO will probably want you to have come to the end of your process in terms of dealing with us before they will look at it.
Yeah, for sure. Wow. I mean, as I say, that your passion for the field, and obviously the passion for all the practitioners out there in this field, is so clear, and this, hopefully this session will be very helpful, I'm sure, to them in terms of the practicalities and some comfort about being in the trenches and where to go and looking at these. So thank you so much again, Claire. It's been absolutely fantastic.
My pleasure.